Welcome to SSI Meetup. Today we have our fourth session with Elizabeth Renieris, Global Policy Counsel with Evernym. And we will be talking about an exciting subject, which is really fashionable right now, which is GDPR and how this is linked to self-sovereign identity. I'm really excited to hear this because a number of people had the opportunity to listen to Elizabeth in different conferences, and this presentation is really highly praised. And Elizabeth comes with a big background in the blockchain community and also in the self-sovereign identity space. She will be telling us a little bit more about herself in a couple of minutes. And if we go to the next slide, just let me introduce you quickly to some of the key things about what we are trying to achieve here at SSI Meetup. One, of course, is empower global SSI communities. What is really important for SSI Meetup is that we want to help global SSI community leaders, local people, to set up their own community so that they can pick up the material, they can pick up these presentations like this one from Elizabeth and start a local meetup or use the presentation and give presentations about SSI and GDPR or any of the other subjects we will be covering. This is really open to everyone. So we want people from the whole industry in the SSI space, from associations, from individuals, from anyone who is interested in doing something in the space to participate. So if you have any ideas, if you want to do anything, please reach out. You have my contact Twitter, but the email is contact@ssimeetup.org, or just check out the website and you have all the different media channels there. And all this content is shared with the Creative Commons by share alike license, which basically means you can use it in whatever way you want. You just need to credit back Elizabeth today because she's presenting with her material and SSI Meetup for using it. And then you will be able to use it in your presentations and everything you want to do across the world. For any questions you might have during the presentations, please use the questions tool or the chat, and I'll be bringing up those questions to Elizabeth as they come up. And that's about it. Really looking forward to this. Thank you everyone for joining today. And Elizabeth, the floor is yours.
Hi, thanks, Alex. Welcome everyone. Really appreciate you having me. So with May 25th looming over us, we wanted to use this webinar as an opportunity to examine self-sovereign identity from the perspective of the liability scheme set out in the GDPR. But before we can examine how the GDPR liability scheme would apply to the SSI or self-sovereign identity context, we really have to take a step back and ask whether it's even a valid question in the first place. The paradigm set out in the GDPR is in some ways at odds with, or at least difficult to imagine from the perspective of self-sovereign identity and its various permutations. They're qualitatively different, so that making such comparison between them in some ways is inherently flawed. So for purposes of this presentation, we'll make some simplifications in attempt to compare the two in general terms before we turn to a liability analysis. And we want to avoid some of the blanket statements that we're hearing and really appreciate some of the nuances of both the GDPR and SSI in a way that's relevant to the analysis. So we'll step back and break down the fundamentals of both, starting from the key differences, and then work towards similarities to frame our approach to liability assessment. So first, the key ways in which the two are inherently different. So first, what are they? So GDPR is a regulation or a law. It replaces the Data Protection Directive of 1995. And unlike the directive, which required implementation by each member state, the GDPR as a regulation takes direct effect in the EU. And in theory, this means that it should result in more uniformity across the Union. On the other hand, while there's no official definition or consensus of what we mean by self-sovereign identity, it's fundamentally an idea or a model for how we manage and conceive of digital identity. Some say it's a third-generation model of digital identity, after the traditional or siloed model and the federated model. In the siloed model, the individual has a unique set of credentials for each service that she wants to access. And in the federated model, an identity provider, or IDP, federates a single set of login credentials whereby the individual can access a variety of services. Think login with Facebook or login with Google. In both models, the individual must act through a third party to access various services and any personal data associated with those services. So what are they about? The GDPR is fundamentally about data protection. Some describe it as a privacy law, but this is only partially true. It's more like a regulation specifically concerned with personal data or data about identified or identifiable individuals. In this way, data protection is really a subset of privacy, and while related to the right to private life, which is in turn related to identity, it's not the same. And just as it's one regulation in the ecosystem of the EU's data protection framework, it should be read in conjunction with other important pieces of legislation, including the e-privacy directive and forthcoming e-privacy regulation, the cybersecurity directive, and others. Self-sovereign identity, on the other hand, is a new way of constituting digital identity. So what's the relationship between privacy and identity? And why is it even useful to compare GDPR and SSI? Well, in some ways, privacy and identity are two sides of the same coin. Whereas you can say that identity is about being known or identifiable, privacy in some ways is about remaining unknown or anonymous. So who is it about? The GDPR only applies to natural persons, i.e. individuals, known as data subjects. This means it does not apply to corporations or to organizations. It also does not apply to dead people, which is actually complex and interesting from the point of view of social media and digital accounts. SSI, on the other hand, extends to any person, organization, or thing, including things like IoT devices, each of which is known as an identity owner and can have one or more decentralized identifiers, known as DIDs, which has been the subject of several webinars prior to this one. And these DIDs enable the identity owner to establish their own peer-to-peer relationships and channels of communication with other entities, people, or things. In fact, one of the biggest innovations of self-sovereign identity is potentially this ability to level the playing field by putting individuals and entities on equal footing. For example, by requiring mutual authentication. So just as your bank wants to know who you are when you call, they also have to authenticate themselves to you. In theory, SSI could also extend to dead people, insofar as DIDs might live on or keys can be passed on or transferred to other parties. And we'll get into this some more later. So what is the data model? As mentioned, the GDPR emerged under the traditional or siloed model of digital identity, whereby lots of large corporations and entities process huge amounts of personal data in siloed ecosystems. The model it sets out is tri-party. There's a data subject, a controller, and a processor. Controllers engage in a variety of processing activities and undertake additional processing with little to no transparency of the data subject, who's literally subjugated to these all-powerful controllers. Self-sovereign identity, on the other hand, aims to decentralize the data ecosystem, putting the individual identity owner, whether an individual person or entity, at the center of her data universe. Rather than the subject, controller, processor model, we have identity owners, issuers who issue credentials about the identity owner, and verifiers who ingest the credentials about the identity owner. The identity owner has full visibility into and control over every identity-related transaction or interaction about her. Other service providers, including software providers that might be facilitating the exercise of self-sovereign identity, including in relation to key management and credentials exchange, effectively act on behalf of the identity owner. So you can start to see why these different paradigms make it extremely complicated in trying to map the GDPR requirements to self-sovereign identity. Another key difference is the ethos. The GDPR is still very much focused on the transactional aspects of our digital identity, which makes sense given that it imagines the commercialization and monetization of our data as it exists in the big data ecosystem, and also given that the second and equal purpose of the regulation is to enable the free movement of data across the union, in other words, to enable commerce. But ironically, it sometimes loses sight of how this second point can undermine the first. Self-sovereign identity, on the other hand, is meant to be more relational. The focus is on forging a new relationship between people, entities, and things in the data universe. People are increasingly interacting with machines. Interactions are increasingly peer-to-peer. The sharing economy is in full effect. The gig economy is substantial. And the hope of self-sovereign identity is that by making our digital lives and data sharing feel more like the way it feels offline or in the real world, our interactions can feel more relational or interactional rather than just transactional. And we see seeds of this ethos germinating in the GDPR as well, certainly in the way it's being used as an opportunity to reframe the conversation in places that may have long been starved of data privacy rights. But what's the approach? Because the GDPR still imagines this tri-party data model and an ecosystem consisting of largely centralized silos of data, it's really trying to manage the world as it is, or rather as it was at the time of the first draft back in 2012. which is per the transactional big data Web 2.0 model that we all know is broken. Self-sovereign identity, on the other hand, is trying to reimagine this data ecosystem and refashion it so that our digital lives mimic the way interactions and transactions have worked in the real or offline world since time immemorial, where we walk around with relative anonymity and selectively disclose things about ourselves to others on an as-needed basis. So, is this old or new? Well, the GDPR feels new, especially to Americans, but it's quite the opposite. It replaces the Data Protection Directive, as I said, which is from 1995. The first draft was published in 2012, but really leaked in 2011, and it takes a snapshot of the big data ecosystem at the time. But innovations since that first draft include AR and VR, smartwatches, myriad smart devices, personal drones, intelligent personal assistants, Alexa and Echo, Google Home, widespread interest in blockchain and distributed ledger technologies, things like Ethereum, and widespread use of smart contracts. In other words, the world has changed dramatically. Self-sovereign identity is at once old and new. It's new in the sense of this third generation model of digital identity after traditional or siloed and federated models, but it's old in the sense that it's designed to restore the balance of how it works in the real world, but digitally. In this way, even though some of the tech might be new Web 3.0 tech, the results should feel more familiar and intuitive to the individual at the center. So with full awareness of these fundamental differences, we can attempt a more honest or apples to apples comparison. But it's important to keep in mind that not all self-sovereign identity is created equal. So for the sake of simplicity, we'll work from the first well-known set of self-sovereign identity principles, namely Christopher Allen's principles from 2016. And for purposes of comparison, we'll combine some of the GDPR's core data protection principles from Chapter 2, Article 5, as well as data subject rights from Chapter 3, Articles 13 to 22. Taken together, it will become clear that there are in fact some important similarities and synergies between the GDPR and self-sovereign identity, especially in respect to the spirit of the law and the framework that it sets out. Turning to these now, some key objectives. So in the physical world, we're anonymous except as needed to interact or transact with others, whereas in the digital world, we constantly overshare. This results in an imbalance of power in favor of the collective over the individual, where organizations are incentivized to collect large amounts of data about individuals to repurpose, resell, or otherwise monetize with little to no consequences or restraints, perhaps until now. As the recitals to the GDPR note, the scale of the collection and sharing of personal data has increased significantly. Technology allows the use of personal data on unprecedented scale, and these developments require a strong and more coherent data protection framework. At their core, GDPR and SSI are both aimed at restoring a balance of power between the individual and collective interests. While the GDPR attempts to do this within the bounds of our existing data model or ecosystem, SSI goes further, imagining a more peer-to-peer driven world with fewer middlemen. Nevertheless, you can see how the objectives are aligned. We'll walk through some of the core principles now and see how the two map to each other. So the first core principle of protection is not a principle explicitly under the GDPR, but of course it's called the General Data Protection Regulation and is in part the whole focus of the regulation. But it's perhaps best embodied in the accountability principle, which is that the data controller shall be responsible for and be able to demonstrate compliance with the GDPR principles. This accountability principle, while implicit in the directive, is now explicit in the GDPR, and controllers need to be proactive about data protection, evidencing the steps they've taken to meet their obligations and to protect data subjects' rights. The accountability principle goes to the question of who should be liable or responsible to individuals in protecting their data subject rights and enforcing their data protection obligations. We'll get into this in greater detail below. Interestingly, in the SSI model, a la Chris Allen, this protection principle is framed as protection against the powerful. And remember that because SSI can extend to entities and can enable these peer-to-peer relationships or interactions between individuals and entities, it literally levels the playing field in a very interesting way without the structural hierarchies of the GDPR model. Next key principle is control. Recital 7 of the GDPR says that natural persons should have control over their own personal data. While control is not an explicit principle, the enhanced data subject rights provided in the GDPR are designed to collectively give the individual more control. This includes heightened requirements for consent and additional limitations on what data controllers can and cannot do in respect of an individual's data. On the front end, Articles 13 and 14 expand the information that must be provided to individuals, whether their personal data is obtained directly from the data subject or from a third party. This expanded right to information, combined with the lawfulness, fairness, and transparency principle, is designed to give the individual full information and awareness to make informed decisions around the use of her personal data. And on the back end, the rights to restrict processing and the right to erasure give an individual the ability to control the use of their personal data after they've shared it, and the right to withdraw consent and the like. In self-sovereign identity, this notion is in part played out by the idea that the individual can have as many identities as he or she wants or needs in the form of decentralized identifiers, or DIDs. SSI promotes control by giving the individual the ability to remain anonymous to others outside of a unique relationship. And this is where the notion of public and private identifiers comes from, which enables the ability to remain known or unknown to more customizable levels than before. Identity owners can establish and terminate their unique pairwise relationships at will without any middlemen involved. Moreover, the identity owner owns or controls their wallets that contain keys, cryptographic information, credentials, claims, and directly authorizes the sharing or selective disclosure of information about themselves. In this way, the entity can also control the mechanisms for sharing their identity attributes and can fire and replace their wallet providers or other providers at any time, and their credentials are portable. All of this collectively enables individual control. The next core principle is transparency. This is largely the same transparency principle as the directive and is related to the rights of information and access, but the GDPR also provides some additional important rights. These are largely borne out in rights in respect of automated decision-making and profiling, including the requirement for controllers to provide meaningful information about the logic involved in the decision-making process, as well as the significance and the envisaged consequences for the individual, and importantly, the right to human intervention on the part of the data subject. With full information and awareness, the data subject is empowered to make more informed decisions. But with more complicated back-end processes and algorithmic profiling, the individual has less transparency and therefore needs enhanced data subject rights. In the SSI version of the transparency principle, as described by Chris Allen, the focus is on systems and algorithms, which admittedly is a very technical approach and makes sense in light of the additional risks posed by these systems and algorithms to the individual. If the individual comes to rely upon more and more sophisticated technologies to exercise their self-sovereign identity, they do require more and more transparency in what's going on under the hood, so to speak, from a technical point of view, which may be a challenge to comply with in the future. The next core principle is access. In the GDPR, this principle is inherently linked to the transparency principle and the right to information and access. Article 15 of the GDPR provides individuals with the right to obtain or access additional information about the personal data held about them and processed by a data controller. Importantly, individuals have a right to obtain a copy of the data held about them, free of charge, unless the request is repetitive or unfounded. But for data controllers, this can be tricky because they have to make sure that in complying with an access request for one data subject, they don't compromise the rights of another data subject or subjects. For example, they might have to redact certain information or consider other ways to fulfill the access right of one data subject without infringing upon others' rights. And where the subject makes the request by electronic means, the data controller should be able to provide the information requested to the data subject in a commonly used electronic form. We'll get into this some more in the right to data portability. And finally, before fulfilling the request, the data controller must make reasonable efforts to identify the individual requester. In the SSI context, people must have access to their own data. The individual in many ways already has access because they retain full control over their personal data at all times, storing most of it either locally in their edge or cloud agents or other software mechanisms. And although the individual has control over their data, they also have a record of every data sharing event with every contact in their data ecosystem. Therefore, they'll be able to prove what they shared, with whom, and when. And if they don't already have the access, they can use this audit trail to demand access as needed. Finally, because of the technical design and architecture, the ability to fulfill an access request should in theory be much easier under the SSI model. Turning to the principle of minimization. The data minimization principle means that controllers must take measures to ensure that they only collect, process, and store the minimal data necessary for the purposes for which it's being processed. This means there are at least 3 dimensions to minimization. It also means the controller cannot make blanket or sweeping requests for data in anticipation of a potential need arising in the future, but will have to collect additional information as necessary as a relationship progresses. For example, an online retailer shouldn't collect payment details until a transaction has to be processed. In the SSI context, it's important to look at each of the 3 dimensions of data minimization separately. With respect to collection of data, SSI might be the ultimate data minimization tool. At all times, the identity owner decides precisely which, if any, attributes it wants to disclose. Using additional sophisticated technology, like zero-knowledge proofs, the identity owner can also exercise self-sovereign identity without ever sharing or disclosing any underlying data, which in many ways is the ultimate data minimization tool. This selective disclosure also means the individual can disclose as many or as few attributes about themselves that they want, and it means that it results in minimized processing of data in accordance with minimized collection. Now, the question of storage often comes up in the context of self-sovereign identity and the extent to which storage can also be minimized. And this is something we'll dive into in greater detail when we look at an example of SSI in the technical context. The next core principle is consent. So consent is a core principle under self-sovereign identity. However, it is not a core principle in the GDPR. Rather, under the GDPR, consent is one of 6 legitimate bases for processing. It's not the only one, and it's not necessarily the best one either. In fact, the recitals suggest the reliance upon consent might be flawed because the standard for consent set out in the GDPR is an extremely high standard. Consent must be freely given. Consent must be evidenced by a clear affirmative action. It must be a specific, informed, and unambiguous indication of the data subject's wishes. And this is an incredibly high bar, although consent is required for certain kinds of data, especially special categories of data. But we're seeing consent notifications and banners popping up everywhere as the GDPR deadline looms. And this may even be worse in some ways than the result of cookie laws that we've had. So the question is, does this become valid and enforceable? Is anyone able to read all of the notices? Is it even possible? Does this meet the GDPR standard of consent? SSI, on the other hand, talks about people freely agreeing to how their identity information is used. And this requires a technical implementation, where, as mentioned before, the identity owner has full access and transparency over every single instance of data sharing in respect of their identity attributes. We'll walk through this in the technical example towards the end. The next core principle, yes?
Just 2 questions here. What's a longer text, but just to share it. Paul is asking, I've been thinking about how GDPR might evolve in the future. To me, as a company whose primary business is data analytics, an explanation, not Facebook, whose primary business is social networking, might be able to have a slightly different interaction with the GDPR legislation. For example, if a company such as Nielsen were to send out a GDPR opt-in email, they might lose 3/4 of their trusted data. Just wait a moment. And then he's saying, as a government level trusted advisor, that loss of data could be detrimental to societal learning. Has this issue crossed your mind? And if so, what would be Nielsen's best approach here?
Yeah, thanks for the question. It's an interesting question. I think we will get to it. So absolutely, yes. And there are large concerns around this, particularly in the context of AI and machine learning and trading data. There is certainly a risk that some of that value could be lost based on certain interpretations of the regulation. However, I think one thing that we'll see and is important to keep in mind is the GDPR is just one of many of the pieces of the data protection framework set out in the EU. And so it shouldn't be taken on its own, but should be viewed in that broader context. Some important regulations, for example, the draft e-privacy regulation, address sort of machine-to-machine level communications and other uses of data more expressly. So that is part of the piece, but it's absolutely been raised as a valid criticism that there is the risk to sort of this collective learning. Now, there are very broad exceptions under the GDPR, pretty much for every provision around historical, statistical, and other uses of data. And it's possible that some of those exceptions will cover this scenario imagined. It's absolutely a great point to raise. Thank you for the question.
Yeah, that's it for the time being. And if anyone else has questions, please just jump in as Paul did, and we will bring them up to Elizabeth as they come up. All right.
So jumping back to the core principles, persistence is an interesting one from the SSI context. Chris Allen said identities must be long-lived or for as long as the user wishes. And this means that the individual has control and choice over their identity or identities, having as many or as few decentralized identifiers as they like, and more importantly, being able to terminate them at will. And this means that the termination of one is confined to one relationship and does not impact or even need to be known by parties outside that relationship. The GDPR, on the other hand, doesn't have a core principle around persistence or not, but rather imagines the data subject having one singular identity that's consistent across contexts and relationships. And while it does have notions of restricting processing and the right to erasure or the right to be forgotten, the problem is that this right, when exercised against one controller, has sort of ripple effects across the individual's data ecosystem, notably because the controller who receives a request must notify and disseminate this request to all others with which the data has been shared, or the public if it's been made known to the public. So this means that when I ask party A to delete my data, it automatically impacts my data with respect to party B and C and other controllers or processors. Again, it's based on this notion of a singular identity. And this takes us to the core principle of interoperability or data portability. Article 20 of the GDPR provides individuals with the right to obtain their data from a controller in a structured, commonly used, and machine-readable format, and the right to transmit those data to another controller without hindrance from the controller to which the data has been provided. What's interesting under the GDPR is that data portability only applies where the basis for processing is consent. Remember the limitations around consent and the difficulty in achieving GDPR compliant consent. It's also limited to where the processing is carried out by automated means. This means it's far more limited than it first appears. And in a world where most entities are organized as centralized data silos, it might make sense that this portability would be feasible. But how does it work when the storage and processing of data is highly decentralized across various kinds of systems? And this is where SSI recognizes that portability alone isn't enough. Portability, rather, requires interoperability. Basically, you cannot move your data if other systems cannot interoperate or ingest it. And this is why the decentralized identifier or DID method that you've learned about in earlier webinars or other methods and standards for decentralized identity have been designed with interoperability at their core. And this is, for example, why companies like Sovereign and Evernym are working closely with Uport and others in the SSI ecosystem to design and build interoperable systems. In fact, this is one of the whole points of the SSI meetup. So based on these principles, which are relatively aligned, we want to look at how liability models under the GDPR would be applied in the SSI context. But I want to first take a step back and review liability in general from a conceptual point of view, looking at the theories of liability stemming from different bodies of law. Then I want to turn to liability under the GDPR, where it stems from, how it embodies these sources of liability and theories of law. And finally, we'll attempt to port that onto the self-sovereign identity context. And we'll quickly see how challenging it becomes. But if we step back and view it from the fundamental tenets of liability and guiding principles of law, we can start to make some progress. So first, how do we assess liability? So what is liability? It's the state of being legally responsible for something. So how do we know what a party is responsible or liable for? We use what are known as theories of law or bodies of law, which refer to the sources of the duties that apply to a person's actions. So first we have statute, which is exactly what it sounds like, or duties imposed by statute or by code. Things like the GDPR would constitute a source of law that is statutory. Next, we have contract, duties freely determined by contracting parties, followed by tort, or delict in civil law jurisdictions, which are basically derived from common law. Next, we have equity, which are duties derived from equitable principles of making a harmed party whole. And finally, which will not be very relevant to us in this context, but important to keep in mind, we have criminal sources of liability, so duties derived from criminal law or statute. So what do all these theories have in common? Every theory of liability is built on duties owed, and a duty is literally an obligation or responsibility, from the Latin due, meaning that which is owed, and stems from a debt or an imbalance of power or control. And this imbalance might stem from information asymmetries, an imbalance of power, including bargaining power, the nature of a relationship, professional duties or fiduciary responsibilities. But ultimately, liability is about power and control, regardless of the theory of liability, whether contract, tort, statute. And when you're not in control, you have to trust those who are. So really, liability is about holding those we trust accountable. So why do we have the notion of liability in respect to personal data? Well, under the GDPR, liability stems from control over personal data. And liability arises in the context of processing of personal data. The GDPR embodies this notion that processing of personal data involves certain risks to the rights and freedoms of natural persons and can result in physical, material, or non-material damage to the individual data subject. So who are the liable parties under the GDPR? The GDPR has what's known as role-based liability. There are essentially two key parties that can be liable for various things under the GDPR. The first is the data controller, who's the natural or legal person, public authority, agency, or other body, which alone or jointly with others determines the purposes and means of processing of personal data. So of course we can have joint controllers who jointly determine the purposes and means of processing. And we also have data processors themselves, who are the natural or legal persons, public authorities, agencies, or other bodies which process personal data on behalf of the data controller. So turning to the bodies of law, we can see how the GDPR embodies these different threads.
Elizabeth, just one thing. It seems, and I didn't know, I was wondering too, that the slides are not changing, that they got stuck in the middle. Is that possible? It's staying at persistence or not right now? Is that correct?
Oh, they have changed on mine.
All right, then we have a technical glitch here. All right, then let's. Well, I don't know if we can solve that now. Just let me find out. Just 1 second. Let me get the other question that was coming up anyway. And let's see if we can sort this out now. In the meantime, maybe if you can close and open again, because Google Slides had some problems last week, and maybe this is part of that problem set. If you close the presentation mode and you go back to presentation mode.
Okay, let me try that.
All right.
Did that work?
Now I see liable parties. That's the right page, right?
Yes.
All right, cool. All right, and then we have one more question here coming from, just one moment. So we have, as you said, GDPR is a regulation and SSI is an idea. But as an idea, SSI is closely coupled with technical standards, example, DIDs. That demonstrates its principles versus GDPR as a legal-only framework. Agree or disagree? This is coming from John.
So the question is, if SSI is principles only, how does it compare to a legal framework? Is that right?
Yeah, I think the question is, what is that? I mean, GDPR is regulation, SSI is an idea, but as an idea, SSI is more related to technical standards like DIDs, and that demonstrate its principles versus GDPR. And this is quite different to GDPR, which is only a legal framework, if I phrase this correctly, John.
Interesting. Great point. So I think one thing we'll turn to in a few slides here is the need for legal, technical, and commercial standards to work together to give full effect to either one of these, whether it's the GDPR scheme or self-sovereign identity. So while it's true that the emphasis appears to be for example, more so on the legal standards under the GDPR and more so on technical standards under SSI. That really comes from a superficial point of view of looking at the two in terms of the principles set out and the language used. But actually, to achieve the objectives of both, you really need to have all three pieces working together. So it's something we'll look at in the context of one example of self-sovereign identity in the sovereign ecosystem. But it's a great point.
Okay, awesome.
Are these changing now?
Yeah, they're changing correctly now. I see them.
Okay,
correct.
Right. So we've got our bodies of law, and then we have this principle of control and liability, which are proportional. So just a quick recap, there are risks in processing personal data. The GDPR takes a role-based approach where the controller and processor are liable. We're going to walk through each body of law now. So in terms of statutory liability, the language of the GDPR holds the controller liable for processing which infringes the regulation and any damage caused. The processor, on the other hand, has more limited liability under the GDPR from a statutory point of view, in the sense that the processor is only liable where it's not complied with processor-specific obligations under the GDPR, or where it's acted outside or contrary to the lawful instructions of the controller. If you remember, the processor is defined as an entity acting on behalf of the data controller. Where they act outside or contrary to the instructions of the controller, they're effectively stepping outside of the scope of a processor and acting as a data controller, and therefore additional liability will attach. From a contractual point of view, recalling that contractual liability is about the agreement of the parties, Article 28 of the GDPR requires that certain contracts are executed that impose specific duties upon a controller or processor. So under the GDPR, controllers may only use processors who provide sufficient guarantees that they will meet the GDPR's requirements, and those guarantees must be put in place by way of a contract. There are some alternatives where there's an approved code of conduct or certification scheme, but largely it will be done through contract. So Article 28.2 requires the controller to have a binding legal agreement or other legal act in place with respect to the processor. And similarly, under Article 28.3, the data processor shall not engage another processor or a subprocessor without prior specific or general written authorization of the controller. So we see how these obligations flow down from controller to processor. Other examples in terms of the contractual liability set out under the data protection framework are things like cross-border transfers that are governed by binding corporate rules or model clauses, privacy policies in terms of service, but they have to be legally enforceable, and other standards in the GDPR regarding the right to information, clear and concise language, and things that will make such privacy policies or terms enforceable or not. Turning to tortious liability, remember that tort stems from sort of four elements: a duty, a breach of the duty, causation, causation and injury or harm. We can see how the language of the GDPR embodies this notion of tortious liability. Now, this language goes across both the controller and processor, and it provides that a person who suffered material or non-material damage as a result of an infringement shall have the right to receive compensation from the controller or processor for the damage suffered. But the controller processor shall be exempt from liability if it proves that it is not in any way responsible for the event giving rise to the damage. So we can see how there's a duty here to the data subject based on the role of being a controller or a processor. There is a breach to that duty in the form of an infringement of the regulation. There's causation and an exemption where the party can prove that it's not responsible for the event giving rise to the damage. And there's injury or harm in the form of damage suffered by the data subject. So to summarize the role-based liability set out in the GDPR, the data controller has primary liability. They are liable for all damage caused by infringing processing, even if not by the data controller. And this is where some of the contractual liability would come into play. They're directly liable to the data subject for damages occurring as a result of unlawful processing, and each controller is responsible for the entirety of the damage. So the GDPR takes the view of joint and several liability in respect of data controllers. The data processor is only liable for breaches of processor-specific obligations, which are largely to do with things like data security, but they're also liable if they act outside the controller's instructions or exceed the scope of their authorized processing. The standards are basically negligence and noncompliance. They must demonstrate this causality, which means that if they can prove that they're not responsible for the damage done, they may not be liable. And finally, they have to look at their contractual liability to the controller. And again, a lot of this will be allocated by contract. So this is all very abstract. And I think it's best to view through the lens of one specific implementation of self-sovereign identity. Of course, because I work for Evernym, and Evernym created the technology behind Sovereign, we'll take a look at the example of Sovereign as one manifestation of self-sovereign identity. So how do we determine liability in the context of self-sovereign identity as viewed through the lens of Sovereign? Well, we apply sort of the broad and abstract principles that we just walked through. And it's basically a four-step process. So firstly, we have to ask if there's any personal data involved. Next, we have to look at the roles that different actors in the ecosystem are playing and identify who's determining the purposes and means for processing of certain data, i.e. who is the data controller in this ecosystem. Then we identify anyone who's processing data on behalf of that controller, so any of the data processors in the ecosystem. And finally, we look at this policy piece of how should we allocate responsibility. So the policy piece is an interesting one from a GDPR point of view, and also from a European data protection point of view. If you look through Article 29 Working Party Guidance, you basically identify three core principles, policy principles in determining liability. The first one is that the analysis should be based on fact rather than a formal analysis. So the facts become incredibly relevant. This means that the technical implementation of self-sovereign identity will become incredibly relevant, and liability cannot be determined in the abstract. The second core principle is that liability should be determined to give most effect to the exercise of data subject rights. So to promote compliance, but also to enable the effective exercise of these rights, to basically allocate responsibility in the way that protects and promotes those data subject rights. And the third, which is really important from a commercial point of view, and again, recalling the second objective of the GDPR is to enable the free movement of data across the union, is that we want to allocate liability in a way that provides sufficient clarity to allow and ensure the effective application and compliance in practice. So this means that if we have an incredibly complicated technical ecosystem, we still want to find a way to allocate liability such that the parties have sufficient clarity and that the identity owners and others in the ecosystem have a clear and effective way of addressing and identifying who to hold liable and how to exercise their rights. So with this sort of four-step process in mind, a reminder on sort of the sovereign ecosystem and this decentralized identity stack, so to speak. So by way of review for many of you, sovereign self-sovereign identity solution consists of largely three pieces working from the bottom up of this slide. So first there's the public ledger, or the public permission distributed ledger, which sits sort of at the bottom of the identity stack. Sitting above that is what we call the agency layer, which is made up of cloud agents and wallets and edge agents and wallets. So the cloud-based agents and wallets are basically remote to the identity owner, and edge agents and wallets are local. That's an oversimplification, but just for purposes of explaining this ecosystem. The edge and cloud agents are basically pieces of software that are acting on behalf of the identity owner to facilitate the establishment of pairwise connections or relationships between identity owners, and also this encrypted peer-to-peer exchange of verifiable credentials. So identity owners will store their keys and other cryptographic data, credentials, claims, and proofs in these wallets. And the identity owners sitting on top remain in control of the exercise of both this credentials exchange and managing their keys and other things. So determining liability in this ecosystem, you basically have to take each step of the above analysis at each layer of the stack and ask, is there personal data? Who's the controller or processor? And finally, the policy layer of who should be liable. So for example, starting with the ledger, is there any personal data on the ledger? Who is the controller or processor there? Moving up to the agency layer, is there any personal data in the agents or wallets? And then on top of that, the policy piece. So what's really hard in this ecosystem is determining these things in the abstract, because both the roles and the pieces of personal data are not static in this ecosystem, but rather depend very much on the transaction or interaction. So what you have here is sort of the prototypical exchange of a credential in the sovereign SSI ecosystem. So you have three parties here. You have the holder of a credential, where that credential is held in the identity owner's wallet. You have the issuer who's issued the credential and signs it, issues it to the holder who countersigns it, and basically can present it to a verifying party who wants to verify the validity of this credential. So these three parties are not static, but rather will move and change depending on the particular identity transaction or exchange of data that's occurring. So in order to assess liability, you have to look at in the context of the transaction or exchange. But for simplicity's sake, we can use this basic sort of prototypical example for assessing liability. So turning back to our questions of, is there any personal data involved? So potential pieces of data that might be personal data in the context of the sovereign ecosystem are things like public decentralized identifiers, private or pairwise decentralized identifiers between two entities within a peer-to-peer encrypted communication channel, the decentralized identifier documents, which have been covered in prior webinars, which include a variety of data points, including public keys, service endpoints, timestamps, and signatures, the credentials themselves that are the subject of an exchange or potentially claims within those credentials, schema, which basically allow issuing parties to then customize into credential definitions to form credentials, proofs, and things like authorization policies, which basically govern the way software agents manage the exchange of credentials. So while this looks really complicated, and it is, an important thing to keep in mind is that over time, all data becomes personal data. So for the time being, many of these things might seem to fit squarely within the metadata category, or rather squarely within the personal data category, remembering that personal data is about an identified or identifiable individual. But the reality is that over time, all of this data becomes increasingly correlatable or linkable to an individual. And because the definition of personal data is so broad, and because technology advances at such a rate where it becomes, as I said, more correlatable or linkable, the nuances of which pieces of this are personal data and which aren't, while relevant now, are also a little bit of a distraction from the risk-based approach set out in the GDPR. So for example, folks are worried about quantum computing, undoing certain encryption standards. The importance of personal data and metadata is, again, it's about assessing the risk to the individual and allocating rights in a role-based way. So while personal data right now is sort of the toxin in our digital ecosystem, and while it's important to know, it's really broad in scope. And again, it doesn't get us very far in terms of future-proofing the effective exercise of data subject rights or allocating liability.
Elizabeth, I have two questions here.
Yeah.
One from Paul, and he's asking, when it comes to retracting data, I've been thinking about implementing a retract overlay, whereby a time limit can be set after which the data is automatically retracted. Do you think that time element should be set by the issuer of the schema or by the owner of the data?
So it's a great question. I think it depends on the aim of the retraction. One thing to keep in mind is potentially, while there's a technically feasible way to retract the data, it may not be possible to prevent further onward sharing or onward processing of the data once it's been shared. So now, on the other hand, it might create an accountability mechanism where there is an auditability of that request to retract or the technical implementation of it. So obviously, from the SSI point of view, it should be the identity owner. It depends on, again, how the data is being shared and what the specific transaction is, and what it's role is sort of in, or how it impacts the allocation of liability from a policy point of view. So it's another one of these factual over formal analyses. I think it's an interesting point. I think, SSI doesn't really solve the problem of, as I said, once the data has been shared, it's been shared. Now, it does have more effective accountability mechanisms, and so there are some advantages there over the traditional approach. But it's it's a great question. Thanks, Paul.
Awesome. And the other one's coming from Jan. Jan is asking, does SSI help the data subject understand why data is needed, how it is used, and consequences of sharing? Technically, it is great. It is a great solution, but how to ensure that the identity owner does not simply share the data without understanding consequences?
Yeah, it's a great question. So in the sovereign ecosystem, we have something called a proof request. And the party requesting the sharing of information has to very precisely delineate what it is that they're requesting and why it is that they're requesting it in the scope of this proof request. And depending on how the proof request is customized or not, and you can see varying levels of specificity that potentially could even have a category of purposes of processing and parties to be shared with, if anyone. So I think there are definitely customizable options within SSI that we didn't have prior, where from a technical point of view, not only do you have the implementation, but you have an auditable record of that implementation. So I do see a lot of potential there for providing enhanced clarity. Now, the UX or user experience is always going to be a relevant piece there, because to the extent that it becomes unmanageable for the individual, you get into questions around things like delegated access and having to rely upon software solutions and other mechanisms where the data subject might not have as much visibility. So it's a question of technical feasibility, but also practical user experience. But certainly, I see the potential there.
Nice. Yeah, that's it for the time being.
So I think we're running a little short on time here. So going back to the slide, so controller processor, again, there's many new and interesting parties involved in the sovereign self-sovereign identity data ecosystem. And again, determining in which role each of these is acting really depends on the context of a specific transaction or interaction, and cannot necessarily be determined in a vacuum. So I think the important thing is to go back to the policy of how we should allocate liability. So again, a factual, not formal analysis, enabling the effective exercise of rights, and providing sufficient clarity. Now, in the sovereign ecosystem, the way that we give effect to these policy decisions is through something called a trust framework. And some of you may have heard of the trust framework already, but it's basically a set of business, legal, and technical policies that collectively inform the allocation of liability within a trust ecosystem. So that specific trust ecosystem can be a broad ecosystem like the whole sovereign ecosystem in general, or it can be what we call a domain-specific trust framework that addresses the unique needs and requirements of a particular industry or interest group or domain, literally. So this is an attempt to, and to the question earlier about, is it just the legal or is it just the technical? From a sovereign point of view, it's really the legal, the technical, and the commercial coming together, because the technical piece provides some of the factual underpinnings of the analysis. The legal piece goes to the statutory and contractual and other liability imposed under the data protection framework. And the commercial piece is really important too. And again, remembering that a second objective of both SSI and the GDPR is to enable this free movement of data. So in that way, these all work together nicely, because to the extent that you can enable trust and clarity and effective allocation of responsibilities, you also enable that free movement and exchange of data. So knowing what a trust framework is, this is basically how it works in the sovereign ecosystem, which is that the trust framework sits on top of an exchange of a credential or an exchange or interaction amongst peers in an ecosystem, and basically expresses these decisions around how does this exchange work, and where are the responsibilities and liabilities of all of the different parties in the data ecosystem. So the trust framework provides, again, this kind of certainty and clarity, and is based upon it's conceptualizing the idea of the contractual and statutory and policy sources of liability there. So it answers these questions of how should we allocate liability. It restores this sort of balance of power through key technological innovations, but also the trust infrastructure. And that trust infrastructure in the sovereign ecosystem, which we don't have time to get into in this webinar, is beyond the trust framework, includes things like trust anchors and trust hubs, the totality of which gives effect to this BLT or business legal and technical approach. And so again, this is the trust framework is fundamentally designed to minimize liability. So in general, and again, it's not the only implementation of SSI, but so in general, how to minimize liability in this ecosystem. So first and foremost is reducing the amount of personal data that's being processed. Everyone by now has heard that, sort of key tenet there is not to store personal data on chain and on ledger, but of course we recall that the definition of personal data is exceptionally broad, and also all data really becomes personal data over time. So the extent to which it's a future-proof solution is questionable. So importantly, you want to look at other mechanisms and not just the technical, as someone asked in a question, but you want to shift that liability in part by contract. And so this is, again, where the trust frameworks can play a big role in allocating responsibilities and by contract, but also taking into account some of the policy considerations there. Relatedly, and again, through a trust framework, you can set reasonable expectations and minimize duties or reallocate responsibilities amongst the parties in a data ecosystem. One idea is to enable valid consent. Again, consent is sort of very much highlighted right now, but very hard to achieve under the GDPR. But to the extent that some of the SSI technology is able to not only enable valid consent, but to provide this auditability mechanism for it, there's potential there as well in minimizing liability. And finally, this notion of identity insurance or other insurance mechanisms for not necessarily minimizing the statutory or contractual liability, but at least for shifting some of the commercial risk. And so there's an important difference there, again, between the commercial risk and the regulatory risk, but also another option for parties to consider. So the big elephant in the room in the few remaining minutes that we have, the right to be forgotten. So ironically, it's actually quite a self-sovereign type notion. As we saw, it's this notion of persistence and determination over how long an identity lasts or doesn't. And it's also this notion of the data is mine and I want it back and I don't want you to have it anymore. So it actually has that ethos of self-sovereign identity. But actually under Article 17 of the GDPR, the right is quite limited. It only applies where one of 6 conditions are met. So when the controller doesn't need the data anymore, consent is withdrawn, and so on. And there are at least 6 broad categories of exemptions, and they're actually quite broad. So the exercise of freedom of expression and information, compliance with a legal obligation, public interest, and so on and so forth. Controllers must respond without undue delay, so generally within 1 month. We can see how SSI, as the prior question acknowledged, might enable that more effectively from a technical point of view. The controller must restrict the processing while making a determination around erasure. And finally, as I mentioned earlier, the controllers must notify other parties of their request if the data has been made public or shared. Again, with the sovereign implementation of different decentralized identifiers and this ability to have private pairwise connections and relationships that are not known to other parties outside the relationship, there's the potential to minimize the obligation there on the controller to the extent that that data isn't public or shared. And then, of course, the question of when the data has been erased. So as we all know, erasure is not defined in the GDPR. There is some guidance from the directive and from other pieces of the EU data protection framework to suggest that de-identification and anonymization might be what's known as effective erasure. The standard is very high. Effectively, the data must be irreversibly anonymized or rendered anonymous in such a manner that the data subject is not or no longer identifiable. We don't have time to get into this now, but there is an upcoming webinar particularly on this subject. But just to be aware that that erasure is still a very controversial topic, and there are many proposals around the extent to which pseudonymization can achieve this erasure standard. Pseudonymization in general does not make something no longer personal data or erased, but depending on how reasonably likely the pseudonymized data is to be used to identify an individual, again, there is guidance to suggest that it might meet the anonymization standard. So all that is to say that there are some upcoming webinars addressing some of these subjects in greater detail that are obviously relevant to the liability conversation. So the first one will be around, is everything personal data? And if so, where do you put things in the digital world? Another one on specifically who is the data controller and processor in a distributed network. And finally, some of the GDPR implications of wallets and agents, which are some of the key infrastructure in this ecosystem. So all of that is to give a broad philosophical overview of how to approach the liability conversation in respect of GDPR and SSI. And of course, in order to get into greater detail, we'll continue to follow up with more specific webinars and content in the future.
Awesome, Elizabeth. There's just one more question. I didn't want to interrupt you here from Stefan. He's asking, where's the personal data stored, if not on Ledger?
Yeah, that's a great question. So again, it'll go to the rest of the tech stack. So either locally in what we call edge wallets or edge agents, or remotely in cloud-based solutions. There are, again, various implementations of SSI, and this will be the specific focus of the next webinar on where to store things in the digital world. So most solutions are recognizing that we want to minimize the importance of the ledger and look to other solutions. But it's certainly a challenge, and hopefully, as I said, we'll get into that in more detail in the next webinar.
Nice. And then there's one more from John. He's asking, can you comment on the role of non-repudiation with respect to liability under GDPR and SSI?
Sorry, Alex, can you repeat the question?
Yeah, sorry. Can you comment on the role of non-repudiation with respect to liability under GDPR and SSI?
So that's a very complex question. We're actually out of time, but as far as in relation to authentication, and basically saying that the author of a statement can either change or remove the association there. I think SSI certainly has potential to give effect to that. I think this will be a very important piece of the webinar on the implications of identity wallets and agents and sort of agent management and software-based solutions for the exercise of SSI. So I don't want to get into in great detail on this webinar, but I encourage folks to participate in the upcoming ones where we will dive deeply into those questions.
Okay, nice, wonderful. All right, so I think we covered all questions. If there are no other questions, please just raise your hand if there's anything else. And if not, that's it for today. Thank you very much, Elizabeth. Please check out ssimeetup.org. You can sign up to the newsletter to get any new webinars we will be doing in the coming weeks. You also have us on Telegram, where you can discuss and join other people and to discuss anything that you're interested in about SSI. And Twitter, Facebook, and all those things. So we distribute all the information, and of course, all this is Creative Commons by share alike. So I'll be publishing this today, and so I'll make it available in all those channels, so you can check out the recording and you can check out the slides. And Elizabeth, thank you very much for taking the time after your very long flight over the Atlantic, and it was great to have you here with us.
Thanks, Alex. Thanks, everyone.
All right. Bye.
Bye.